Good afternoon, good evening, everyone. My name is Mohammed Badawi, and I'm going to be the host for this webinar today. I'm going to share my screen shortly so that you see the presentation that we are going to go through today. So the title of this presentation is From Bytes to Verdicts, the Art of Digital Forensics in Litigation. Before we start, I want to just briefly make sure that everybody hears my voice. Can someone write in the chat, please, that if you hear my voice? Perfect. Thank you very much. So today, my goal is actually to convince you that a topic that might seem dry can be a compelling and enjoyable story. I'm saying this because in modern litigation, the digital evidence now is becoming the norm. It's not like before when we had the physical evidences where the forensics experts used to examine and provide the verdicts eventually. Today, we are dealing with a lot of digital data, with a lot of digital evidence, whether it is in systems, whether it's on phones, or in the cloud, or any other place. And that caused a lot of disputes to depend heavily on digital evidence in order to prove the case in the court. Before that, I want to introduce myself. I am Mohammed Badawi. I am the CEO and the CISO of Trusted Systems Consultancy in UAE. I used to work in IBM and I worked for Emirates Airlines. I worked for Injazat Data Systems, C4, and the government, and these are all companies in the UAE. I specialize in complex data breach investigations, evidence recovery, and expert witness testimony. I'm a court-registered expert, actually, in Dubai courts and soon I'm in Abu Dhabi courts and soon in Dubai courts. And basically what I'm doing is bridging the gap between digital evidences and legal proceedings in the courts. I am an INSEAD business school graduate. I have an MBA from INSEAD. I have a master's degree in cybersecurity. I have almost all the big certificates that you can think of, CISA, CISM, CJ3, RISC, CSP. I don't want to bore you with that, but this is just some of the qualifications that I have. I am technical in nature, but after some time you get bored of technical aspects and you start going into more managerial, more into having others to perform the work, and then you review their work. Unfortunately, in the past 5 years, I had to go back into technicalities. That's why I started working again in digital forensics, into investigations, and so forth. Today, I'm going to talk to you about 2 study cases. I don't want to make this a boring presentation. I want to make it a little bit enjoyable so that you appreciate the value of that science that not many people actually are doing today, because they usually think about it from cyber incidents handling perspective. However, there are other aspects in life that usually technical people do not get involved into unless they are working in similar field like the field that we are working on today. Imagine coming into the office on a nice morning, sipping your coffee, and suddenly you start getting a lot of calls about a system that is not working. This is exactly what happened back in 2022 when a government entity call center started getting bombarded with calls from users complaining about a system that is not working. And that system is actually a critical system. It's the cash cow of the government entity. It's an e-services software that is published over the internet for people to register their licenses and get to work into the country so that they operate their businesses. It's just a trade license issuance software. And they started doing the normal investigation. They started to do incident response, trying to go and find out why the system is down. Maybe it's a network issue, maybe it's a DNS issue, or maybe it's something to do with the server. And the normal investigation cycle went on. However, it led to nothing. Eventually, they had to call the vendor who developed the software for them. The vendor came quickly to their office and tried to start investigating the issue. They went ahead right away to the application. They found the application working fine, but the disaster struck when they went to the database and they found that there is no data whatsoever on the database. That obviously was a clear shock for them. Why the data is not there? The application was working the night before, nothing was wrong with it, but suddenly there is no data in the database and now the system is not working. Now, this is a high visibility system. It was on the highest level on the government side, so they had to work quickly to understand what was going on. And how I knew about this, because 1 year later, the vendor's owner was facing jail time and heavy fines, and she called me asking for help quickly because she's about to get prosecuted, and suddenly they're going to issue a verdict against her. The accusation from the government entity to the company was that they sold them, they committed fraud actually, and they sold them defective software without telling them about the defects in the software, and hence they should bear all the damages that happened in that software. Now, after a deep dive into the logs, the team was able to identify that there was some weird logs entries or weird log entries that had some kind of strange commands into it. Upon looking, the developers were able to confirm that these were SQL statements, and obviously the attack was a SQL injection. And the attacker was able to compromise the system through the web interface, and he was able to log in to the database without authentication. Obviously, through that web interface, he was able to inject the code and effectively dropping all the tables of that software. There is obviously there is no data after you drop the tables. The extent of the damage was clear when they realized that it wasn't only the database of that application, but also all the other databases that were residing on the same server at the same time. And then the IT team of the government entity told them, yeah, we started getting also calls about other systems not working. And obviously, this was like a big shock to all of them to learn that the attack was massive. The attacker was able to delete the entire database server and made it clean. There was no application whatsoever that was connected to that server was working, and they were not able to restore it in time. The problem wasn't here, actually. The problem was bigger than this. Because of the SQL injection that happened, obviously, some of you might know about the SQL injection attacks where the attackers write some kind of SQL statements into input fields. This is where there is no input sanitization, and hence the database server gets the commands from the web server. And if that command was a self-destructing command like what happened here, then it's going to destruct the entire database. The big problem was actually that they didn't have actually backup. And this is one of the issues that was very strange during that incident. This is a government entity. They're supposed to have the resources. They're supposed to have all what it takes to protect themselves from incidents like this. However, unfortunately, there was no backup at that time. And despite the system being a new system that was developed like a year ago or so, and unfortunately, they couldn't recover on time. The whole thing got to get revealed when a former employee admitted to attack the database. He was participating in a similar project where they used to use the same framework that they used to develop that software for another entity, and then they use the same software now with the new entity, and he was aware of the source code, he was aware of how the software works and the database structure and so forth. That's why, despite the fact that he was able to do SQL injection, usually it's not easy for them to understand the schema and understand what's going on behind the scenes. It takes them time, and this guy was able to identify the tables and delete everything. But before he does that, or before he did that, he took actually a copy of the data and kept it with him just to blackmail the company for money, so that he gets his revenge because he didn't participate actually in this project. He asked to be onboarded on the project, but he was discarded because he had some attitude issues, which led to him not being part of the project. Having said that, he requested 1 million of the currency of the country where that has happened in exchange for him returning the data. And actually, I didn't write that in the slides, but he actually contacted the government entity and he told them, I can help you restoring your data, without mentioning the fact that he has a copy. But he said, I can help you fix the data. If you want, I can work as a consultant with you or something of that sort. What happened next is that the team in the company or the vendor tried to work with the IT team and the government entity to try to identify if there was any kind of backup where, and unfortunately, they couldn't find an official backup, but in one of the developers' laptop, they found a copy of the data. It wasn't recent. The developer actually downloaded it, luckily, just to do some tests on the application before pushing it to production. So despite the fact this is not a good practice, obviously, to have test data on developer's laptop, but in this time it was a supportive aspect that helped them actually restore some or a great set of functionality to the application. So eventually the system was rebuilt, but then when the system was rebuilt and everything went back to operation, the government decided to sue the vendor for damages because of the problem that has happened, despite the fact that they were able to, they were the ones who helped them restore the system. But again, because it was embarrassing, it was in front of everyone, so they should have found some kind of sacrifice lamb to take it to the court and take back their image if it's going to be restored in that way. Actually, they sued the company, they sued also their internal employees, the backup administrator, the security team, and everyone who was part of this thing, because they thought that those people are the ones who are responsible for that kind of breach, and all of them had some share of it. For example, the backup administrator, when they asked him, why didn't you take backup? His answer was that, well, I went to my manager, I asked for backup tapes, but my manager told me that we don't have budget, hence I didn't have backup, and hence I don't have any responsibility to do with that. The court asked them to provide the evidence for that, like, for example, if there is an email or something from his manager saying that this was requested and he was denied the budget, but then he failed to provide that evidence. This was part actually of the proceedings during the case itself. The security manager also was prosecuted because he accepted actually some of the findings because he thought that these are the only findings that he has. So obviously what happened is that SQL injection was there in the system. It wasn't detected before the go live. And after the fact, after the incident itself and after the recovery, they brought a pen tester who came and he found it like in 2 minutes. He was able to find out the SQL injection attack, and he was successful in accessing the database. And if at all they were able to do that before the incident, they would have prevented that kind of incident from happening in the first place. And they actually, according to the security manager, what he's done is that he did dynamic testing on the application level, where he ran a vulnerability assessment tool, and the tool generated some medium severity vulnerabilities, which also were not addressed before the go live. So he had to give an exception or sign an exception to go live with the application in and fix the vulnerabilities after the go live within a month or so. So he's like having a plan to fix that. The problem is that he was the one who signed off on that, whereas he shouldn't have done that. He is not the owner of the application. He is just a facilitator in that case because he's the security manager. But this is how it went. And that's why when he went to the court, he was responsible actually to answer for all of these findings and issues that were not mitigated in time. In terms of financial loss, actually, there was a huge financial loss. There was that application was generating hundreds of thousands of the currency of the country that where this was happening. and they were able to, and they lost actually that revenue, and they were just daily losing money until the application was restored. The problem wasn't over here. Obviously, it wasn't only the financial loss, but also about the reputation damage that happened to that government entity. Imagine you going to trying to you go to try to register your trade license, and then suddenly your trade license is cannot be registered because the portal is down, which is something could be normal. But then you hear in the news or you hear from others that, oh, there was a breach and that government entity was not able to issue the license for you. Let alone the bigger problem that happened actually is that some of the issued trade licenses were gone because the data of those couple of days where the incident was active, there was no backup of it. So it led to a lot of chaos actually when the people came for renewal. Some of them were told that we don't have a record of your license, and they were asked to supply lots of evidence, and they had to re-register them again and so forth. So it was a chaotic situation actually for them. And in terms of the legal, there was obviously massive productivity loss, and there was a lot of legal proceedings. The case went at least for 2 years just in the court between different levels, and the people were called multiple times to attend the court sessions, and there was experts assigned from both sides, and it was like a massive, massive painful process for everyone in that sense. Now, when the owner of the company came to me, she said, listen, I'm facing jail. I cannot go to jail because this is not what it should happen. We didn't do anything wrong. What we've done is we sold that software to them. We gave them the source code, we gave them everything. And even we told them that if you have any security requirements, please let us know ahead of time so that we go and implement it. Immediately, I asked her, do you have an evidence of that sort? Like, for example, do you have an email? Do you have any kind of correspondence between you and them that proves the fact that you asked them for that kind of security requirements? And she said, yes, I do. And she showed me the email. The email was authentic. It wasn't tampered with. We examined it, and we found out that indeed they asked the government entity to provide them with the security requirements. However, the government entity said in clear, response that don't worry about the security. Our security team is going to conduct penetration tests, or they're going to do some kind of assessment. They didn't say penetration tests. They said they're going to conduct their assessments prior to going live. So you don't have to worry about it. That email was crucial in proving the fact that the security responsibility shifted from the vendor now to the company, where they are the ones who are going to do that kind of assessment. And as you know, in applications, the golden standard for identifying weaknesses and security issues is to do penetration tests. And unfortunately, in this case, it wasn't requested from the vendor, nor was done by the government entity itself. Eventually, what happened is that the prosecution, and this is the public prosecutor because they were representing the government, they were arguing that there was a hidden malicious code in the application. And this was funny actually, because when we examined the claim, they said that there is a function in a JavaScript file or in JavaScript code that is in the front end of the application. And we went ahead and we were able to identify the function and take it out from the browser, because obviously that front end code is going to be executed into the user's browser. So it was a very stupid claim. However, this is the problem with when you talk to people who don't understand things and they try to make judgment on things that they don't understand. And obviously, the public prosecutor is not a technical person. He tried to make it looks like those people were cheating the government entity and they were trying to hide some vulnerable code in that place. And we refuted this completely. We told them, we explained to them, and sometimes you have to write stupid arguments in these kinds of responses, because you have to explain to them what does it mean to have that code in that place. And it's very difficult, obviously, when you're talking to someone who's not technical. Imagine talking to someone within IT who's not specialized in software, and you try to explain to him about CI/CD, for example. And this is not an easy thing to explain, obviously, if they don't have the basics. We had to do all of that. Also, we demonstrated that all of these UI scripts can be generated, and it was not obfuscated. And we proved the misrepresentation or misinterpreting of the prosecutor, and we moved on. Now, this is just a sample, a small sample of the report that we generated. I remember the report was more than 70 pages, where we wrote exactly about each and every finding and each and every accusation that was put forward by the public prosecutor. Some of these arguments were that they were trying to say that the government knew about these errors ahead of time, and you know, they put it even while they're knowing that, and they didn't explain that to the government entity. But obviously that wasn't the case. They spoke about so many other things that were sometimes not strong, or they don't have evidence over. The funny thing is that for the others also, they were who were prosecuted from the government entity. They were not the first accusers. They were like the third or fourth. They were focusing mainly on the company, and they wanted to take them to jail. Actually, this case from the first degree to the appeal, and then to the final Supreme Court, and then went back all the way to the appeal again, and eventually it was very successful victory, and we were able actually to win that case, and we exposed all the failures, as I said, like the zero requirements, the phantom assessment that they've done internally, and eventually we helped the client to clear their names, because we couldn't find any evidence that there was negligence from the side of the client. Our client actually expressed what's known as due diligence in this case. They did the due diligence and due care, which are terms to refer to taking all the necessary research and doing all the necessary actions to avoid that kind of thing from happening. Obviously, the government entity, because of getting involved into the situation that way and not actually guiding everybody in the right direction by, for example, mandating a pen test from the company, mandating certain security requirements, they were not able to prevent that incident, let alone obviously the lack of good incident response, the backup issue, the assessment, the approval, the risk management framework that was broken, and so forth. At the end of the day, when you reach to the court, it's not about just having some kind of circumstantial evidence. You have to have real evidence that proves beyond certain doubt that this person have done this thing. That's which is one of the most difficult things we face in the digital forensics world. However, in that case here, because this is a case of argument, you have to argue that your client did not do wrong in a while they mean to do that, because if there is no intent, there is no crime. This is because we're talking here about criminal investigations. The whole case here was a criminal investigation. It wasn't a civil claim. What usually happens is that you prosecute people on a criminal basis. Then if you win the case, you go and apply for the civil claim. And because they didn't succeed, obviously, in the criminal case, they were not able to also pursue the legal action when it comes to the other side of the fence, which is the civil claim. I hope everybody is still enjoying and engaged with us in the presentation. I have another story actually to tell you, and that story is actually very recent. Again, I was called at late night by some young, lovely person who called me, and he said, listen, I've been searching for someone to help me for a very long time, and finally I got recommendation to contact you because I have a big problem and I have to deal with it. And I asked him to explain to me what is the situation. And just to give you context, this person was a high achiever, top scoring cybersecurity student. He was on a full government scholarship to study cybersecurity in one of the local universities. And he was receiving actually a monthly salary from the entity just to, encourage him more to be hardworking and to deliver as much as possible, with a guaranteed job waiting for him upon finishing the university years. What he was accused with was a very stupid thing, actually. He was accused of hacking the university to change his grade from 90 to 92. And this was actually in a basic math class. He was taking one of the math classes, I think, because he used to study cybersecurity, so he has to go through computer science, and part of computer science to have to go through math. And in the system of the university, there was no A plus actually. There was maximum of A, and he was already at A because he scored 90. And they were able to confirm that by looking at his exam paper, and indeed he was scoring 90 in the exam. So they accuse him of hacking the university to modify his grade from 90 to 92 in all possible ways. Some people might argue that, oh, 90 to 92 might actually help his GPA, but obviously this is not going to help. Two marks, it's not going to help anywhere because of he was actually in the graduation year. So it was like a couple of subjects and he would graduate actually. Actually, this guy was in his last semester when this thing has happened. So the question should come actually, why risk a golden future for 2 marks in a basic class where you already scored an A? There was no motive whatsoever, right? However, for us as digital investigators or digital forensics investigators, we do care about the digital evidence. That's fine. There is no evidence. There is no motivation for that student to do the whole thing. But this should be something that you keep in mind while you do investigation. You have to give the student a little bit of benefit of the doubt to play some kind of devil advocate game in that case. When the student went to the court, actually he sued the university. And the reason behind that is that the university claimed that based on the evidence that they have, which is the IP address that was used to access the Office 365 email of that student, which was the same IP address that is used to modify the grades. They said that indeed this was him, and hence they concluded the investigation. Despite the fact, if you look at the logs that was presented by them in their report, it says that the person who modified the file was unknown actually. It was saying that anonymous user went in, with a link or something to Office 365. You know, you can share documents on Office 365 with anonymous access. And the person was actually allowed to access those files, modify them without any kind of authentication. This, among other non-relevant evidences, just they concluded the fact that he indeed was the person behind it. And obviously, this is a failed, investigation because without trying to bridge the gap between or try to identify all the possibilities of why this student have done this, or how could have that IP address appear in your logs, this wasn't investigated whatsoever. They just found out that his IP address was matching to the IP address of the modification, and then they concluded the fact that he was the one who done it. One of the things that we usually do as court experts is that once we get an IP address, we go back to the telecom companies and we ask them to provide us the information about the ownership of that IP during the time when that incident has happened. And this information, if you go beforehand or in a timely manner, you'll be able to get the information from the telecom companies. Obviously, you have to go through the official channels so that you get that, like you have to get from the telecommunication authorities in the country, and maybe even the security have to get involved into this. But anyway, they've done none of that. They just use that IP address to correlate with the person. One of the theories, and it's a strong theory actually, that we put forward to them, we said, what if that IP actually used to belong to you, to the university network? Because obviously you're going to be using a NATed IP address where everybody's going to come out from that IP address and log into that. They didn't do any kind of investigation of that sort, and they issued that report. And based on that report, unfortunately, the person was fired from the university, and he lost his scholarship. He lost his job in the entity that offered him the job, and he lost his salary. In addition to losing 2 years of his life because he had to go back 2 years in a new university because there is limitation in the amount of courses that you can carry over from the old university to the new university. So it was a complete disaster for that person. They ruined his life, I would say, his young life. He still have some time in front of him, but anyway, it wasn't a pleasant experience, obviously. When the court expert, when that person went to the court and he sued the university for damages because he said that they wasted my future, they did all of these things, and he was demanding, compensation for all of that. The court expert, unfortunately, went ahead and took the report of the university and depended on it to prove that the student have done that. And this is when I got the call from the student. He said, listen, I know that what's written there in the report is completely wrong. I study cybersecurity. I know maybe I'm not experienced in the domain, but I know that what's written there is not correct. I myself I checked with my friends who are working in the law enforcement into the digital forensics labs of the police and things like that. And they told me that, yeah, this is wrong, that to take the evidence in that way. The problem with taking the university's report as is that the university did not use a solid methodology to identify whether these logs or these evidences were actually correct. You have to do that actually to make sure that this person indeed have done that. You cannot just depend on the fact that yeah, we think that his IP address is the one who done that. You don't just go and see that his grade was modified and then you depend on that. These are very weak evidences, and it has to be beyond certain doubt that this person have done that thing. So when the court expert went, he didn't ask for logs, he didn't ask for the evidence, and he just was dependent completely on the university report. So I got a copy of the report of the expert who was appointed by the court. When I looked at it, I said, this is a joke, because literally it was a joke. I mean, I looked at the investigation that he've done. He didn't do any kind of investigation, to the extent that I thought that he wasn't the one who wrote that report. It was a very basic report. It wasn't something that proves that this person have done this thing. A good forensic report or a good court report should be, I'm talking about technical reports here. I'm not talking about legal documents. I'm talking about the fact that when you read that report, you should be able to say, yes, this person have done exactly the thing that he's accused of. But unfortunately, I got a zero sense when I read that report, because it wasn't telling me what exactly or how they depended on, what are the things that they use to prove that this person have done these things. Obviously, they ignored certain things that appeared later on in the case. When we wrote our report, I wrote a counter report saying that these are all the shortcomings, and not only in the expert report, but also in the university report, because the university report was lacking lots of substantial evidence to prove that the student have done these things. And when it went to the judge looked at my report, and he ordered the court expert to go back and find all the evidence from its original places. And he gave him hard, words in the report. You can in the judgment. It was very clear. You can read between the lines that the judge wasn't happy actually by the work that was done by the appointed expert. And he asked him to respond to my report point by point. And he said, do not give me evidence that was produced by one party, because there is a chance of fabrication or there is a chance of wrong, which was the case over here. We don't accuse them of fabrication, but we accuse them actually of not doing proper job in investigating and finding out that the student have done that. One element that they ignored actually is to mention the fact that this person suffered from an attack, and he reported it to the IT, but the IT team did not take any action about it. He said that my email is behaving weird. When I log into my email, I found out that there was emails that were sent from my email. I didn't send those emails. I have nothing to do with them. And it was during the same time where other people also in the university were suffering from similar things. What turned out later on that they admitted when the court expert went back again, they discovered that the there was an attack on the university network, and the people obviously they didn't know who did that because they didn't do the investigation again. But there was people who are not related actually, or students who are not related to that person whatsoever. In another section, for example, the university have separation between men and women, or between boys and girls. So in the girls section, there was also some modifications of that sort, which means that there was someone who was playing just around in their network and modifying the grades right and left. They ignored that pattern also. They didn't include it into their investigation. And they hid it when the expert went to them. They didn't tell him about him. But next time when the student brought it up, he said, what about the other attacks that happened for other students? What did you do about it? And obviously there was no response. They said, yeah, we had those attacks, but it wasn't actually captured. They didn't have logs actually. Now, what we've done is we broke the entire argument that came from their side. And again, the reason behind it is that they didn't have sufficient evidence to link to the student. The student was, his life was ruined, obviously. There is no way for him to recover those 2 years and the amount of money that he lost and the chances that he lost in his life. But he was happy. I spoke to him 2 days back. I asked him what was the ruling in his case. He told me that, yeah, they ruled in my favor this time and I won the case. However, they didn't give me the amount of money that I was asking for, because these are the damages that they caused to me. I told him that maybe this is, it's not about the money only, it's also about clearing your name and going back maybe to the entity that was providing you the scholarship. And at least if you don't get your job back, you tell them that, hey, I was cleared from this by the court itself, and this is not gonna affect you as you go in future. Now, what do we learn of all of this? We have to learn multiple lessons here, and this is based on my experience now doing this for the past 6 to 7 years. You have to exert due diligence. This is what happened with the company that was cleared in the first case study, where they've done their job, or at least they try to do their job according to the book. They had everything written in the contract, and they tried as much as possible to help the client, to show the goodwill from their side, because they were genuine. Actually, they were trying to help the client, not to hide behind the legal proceedings and things like that. Now, also, this is when you are on the side of the person being accused. But also, if you are an expert or trying to judge on a case, never rush to conclusions, especially when careers at stake. You need to verify. You need to make sure that everything is correct, everything is right, and do not just rush to conclusions. The problem with digital evidence is that it is very fragile. It is subject to tampering easily. That's why you have to take all the measures necessary to make sure that what you've written there in your report is actually accurate. We reject lots of cases that come our way because they don't have sufficient evidence, or the argument that is put forward does not stand on solid grounds, because we think it's better to not write a report and lose the amount that we're going to get from that report just because it's not something that is substantial. The other thing, basic hygiene in the government entity's case, obviously, basic control like backup was missing. And again, I don't know how an organization in this day and age do not have backup with all of the things in news like ransomware and other types of attacks, let alone trivial things like that where you don't have any kind of protection in front of the application. Obviously, today, the golden standard is not to put an application right away on the internet. You have to put a WAF or put something in front of it to protect it from unauthorized access. But again, if you had to go live with a critical application like that, you have to at least have the basic hygiene, things like immutable backups where those are not modified. And also you need to tighten your risk management methodology, because this is not a joke, as we are going to see shortly. And one of the things that you should do, despite many people don't like it, is that you have to document things. You cannot believe the amount of cases where documentation saved the clients in either proving that there was some wrongdoing from their competitors or from their employees even, and the amount of time that also, because things were documented, people went out of trouble. I remember in a case where we had a government entity against a big service provider, a big actually consulting firm. They were accused of failing the project because of those consultants. And one small clause written in the contract saved the consulting company from all the hassle. It read that if the deliverables were delivered within 7 days and we didn't hear anything from you, these deliverables are considered acceptable from your side. And this went all the way with all the levels in the court, and they won the case because of that. So do not, I'm not saying document everything as in each and every word that you say, but the critical things, the things that, for example, if you have an acceptance on a project, or if you have acceptance of risk, or you have change in the project, change management. Change management is very important, and contract management. This is what we did. We deal with day in and day out in all the disputes where people are not paying attention to these things. Risk management is real. It is definitely living and breathing. If things go south, you're gonna be called to answer for these things. Why you signed off on that kind of risk? That's why I tell all my dear friends who are doing cybersecurity and doing specifically risk management or GRC, do not sign off on risk. You are not the owner of that thing. Let someone else, sign off on that. Even if they don't like you, even if you ask you to take it to someone else, please do not sign it off on yourself, because this might come back to you. And obviously, do not sign off on stupid things like apps of backup. Do not sign off on things that might compromise the environment. Do not accept, for example, going live on a web application without having a pen test. I don't think this is something that we have to talk about. And the denial factor, keep in mind that people will say things at certain point, but then they are going to come and completely deny it afterwards. And this is why digital evidence is the only objective truth in the room, full of subjective memories and subjective defenses from the other parties. That's why trust the data, but not the interviews or the claims of other people. They seem nice to you today, but tomorrow they are not going to be the same. Now, all cases boil down to two things, in my opinion, and this is my view after being in this domain for the past 6-7 years, doing that continuously. It is obviously building a case on a solid evidence. That evidence has to be protected. That's the things that we hear in forensic classes about the chain of custody and about the handling of the evidence and these things. These are very important aspects. The other thing is the skill of the analyst or the skill of the person who's going to make the verdict, because usually courts will not do that kind of work because they're not technical. The judges are not that technical. So they are going to ask other experts to work with them on these matters. And that's why having objective evidence, having things that are not just arguments, is the only way for you to pass that thing. That's why you have to be skilled and your team has to be skilled, and also you just need to pray that you get a good expert who's going to understand the things that you wrote in your report, so that at least in that level of litigation, they are going to give you the benefit of doing hard work and proving the evidence, what the evidence is saying. Tools do not solve cases, people do. So maybe you have the most advanced tool of in forensic science and equipment and things like that, but at the end of the day, it's about how you use these tools and how you settle a dispute or work on some kind of investigation using these tools. And this is where again the skill part comes back into the situation. With that, I finished my presentation. I hope that I didn't bore you as I promised. And I'm really happy to be with you today, but I'm now open if you have any questions, if you want to ask me about anything, whether it's related to the cases that we spoke about or anything else regarding the digital forensics investigation. I'm here to help and answer pleasurably. So Matthew is asking, what skills beyond technical mastery will be most valuable for forensic experts who want to be effective witnesses in high-stake litigation. Actually, you need to understand a bit of law. There is always the burden of proof is on the person who's accusing of something. So, for example, if I accuse someone of hacking my network, I have to be the one who's providing the evidence that someone went into the network and he hacked, and this is what proves that he was behind the keyboard, he was accessing my network from that IP address, he used this identity, and so forth. So that kind of where you utilize the legal knowledge to use it to find out what supports it from the I would say from technical perspective. With the rise of encrypted ecosystems and ephemeral messaging apps, what are the new blind spots investigators face, and how are forensic methodologies adapting? Frankly, we have a challenge actually right now with the digital forensics generally. It's not only the ephemeral messaging apps where messages disappear and things like that, and I can tell you in another webinar maybe about the smartphone forensics that we do. We had a recent case about that thing. The problem with these new mobile phones is that you don't have access to the actual storage, and this is what we call physical access. In the case of laptops like this laptop in front of me, now we have access to the hard drive, and we are able to retrieve even the data that was deleted at some point. With mobile phones, unfortunately, this is not the case, because in mobile phones, you don't have access to the physical hard drive. And hence, if the data was deleted, you'll not be able to recover it. The other thing with the deleted apps, I'll just give you a glimpse of that case. The case was actually in someone was accused of sending a message and then deleting the message. We were able to find the message eventually. We found it into the WhatsApp database, but it wasn't the same message that was sent. So there was some kind of tampering that has happened on the other party's phone to show that this is the evidence, because they went to the electronic evidence department, and then there they found that they said that the message was found on the other person's phone. But when we examined our client's phone, we couldn't find, despite we went into the database itself, we were able to see that there were traces of message. The deleted message was so obviously, just to give you quickly how WhatsApp works, even if you deleted the message, there will be a trace of that message in the database. It's gonna be empty.